Friends, we are starting in 1 minute time. Just checking some of the things. Okay. Friends, today I'm going to talk on the subject of Supreme Court judgment on daughter's inherent right under Hindu Succession Act. We are organizing under the banner of Isaka Ahmedabad chapter. I'm CA NITIN M PATHAK. We are going to, tomorrow the budget is going to come. We are going to talk on the budget very shortly. After that, there will be an immediate budget talk, which would be in the people's mind. इसका मेन पर्पस ये है कि एक मिनट हाइड वीडियो पैनल. ओके, हाइड, मेरे को वीडियो पैनल नहीं चाहिए. Oh, sure. So sorry, we missed something. Let me restart because. Okay, now are you getting it properly? एक मिनट अंदर आ जाए सर. Friends, I'm just starting, and this initial problem is going on, but now it is okay. Okay, we are going to talk instant budget. When budget comes in, what is important for you would be talk to you on the subject within 2-3 hours. Then later on, we go by each section, each fundamental to be learned and to be used by chartered accountant mostly. But it will be in-depth analysis on that. And we are going to talk on economic survey. What is the purpose of economic survey? Economic survey के purpose करने के बाद what will be the implication for each sector and how India is going to be in the scenario of the world and what is in the mind of government where India stands and what is the government is going to take corrective action or supporting action. This would be budget qua economic survey. Then we are going to talk on in-depth analysis of the budget 2020, which I have already told. And I am going to talk on the subject of depth of decoding of budget, decoding GST. अभी real sector में क्या होता है कि builder, works contractor, which comprise a very huge economic budget. तो कमर्शियल में क्या होता है, रेसिडेंशियल में क्या होता है, प्लॉट डेवलपमेंट में क्या होती है, उसका कौन सा खर्चा है, कितना जीएसटी लगता है. People think that we pay 5% or 1% GST for economic and other sectors and we have to done with, but there are a number of permutation combinations which we need to take care. We are going to explain in detail because GST is a problem. If you miss anything, then you have to pay a huge penalty. Next week, matlab on 4th, we are going to talk on liability of internet by intermediary as per Income Tax Act by by Speaker Avichal Sinha from Bangalore. This is the link. Then we are going to talk on in-depth analysis of budget on 9th. We are going to be which here we will cover each part of the budget. We are going to talk on in-depth analysis, which I already talked. There are different seminars which are going to be conducted 31st, 4th, 9th, 18th, 12th, 25th, 4th, 11th, 18th. We are conducting under the banner of Isaka chapter. And today we are going to talk analysis of budget, analysis of Supreme Court judgment on daughter's inherent right under Hindu Succession Act. Recently, Supreme Court two-bench judge has delivered a judgment which was widely circulated, widely discussed. The fact of the case was that the father died intestate, daughter was not allowed by the lower court as well as high court. They say that as his father died intestate, there are three kinds of property: father's own property, inherited property, and joint Hindu property. They all were not allowed to be used by the daughter. The father died in 1949. The court today in 2022, the judgment came, and judgment clearly laid down the principle on the basis of which the daughter would have an inherent right of the property, including all the three kind of property, instead of collateral. कोलेटरल का जो भी डेफिनेशन है वो मैंने पूरा एक हिंदू सक्सेशन एक्ट डिकोड कर दिया। हमने हिंदू सक्सेशन एक्ट में किसको अप्लाई है, किसको नहीं अप्लाई है, कौन से प्रॉपर्टी को अप्लाई है, एंड वी गिव डिटेल वेदर फादर एक्सपायर हो जाते हैं या वुमन एक्सपायर हो जाते हैं, क्या होता है, इसका पूरा जनरल लॉ हमने डिस्कस किया है। वंस यू गो थ्रू दिस एक्ट you would be understanding the importance of will. And after 2005, what are the fundamental change in the right of a female in the property of father and grandfather and intestate property is discussed here. With this brief, what I'm going to cover, I'm going to cover each section now by each problem. The content of this include, मैंने आपको बता दिया. Can inherited property self-occupied with the absence of will, which was discussed in NDTV? Preference to daughter over niece and nephews. Niece and nephew in this definition is considered as collateral. Now it would be the part of the main game. Daughters to inherit self-acquired property or those obtained in partition of family property if rather than died without a will. Daughters to get preference even if father lived in a joint family. Joint family hota to it is clear that ancient texts, smritis, and even judicial pronouncement have recognized the right of several female heirs and wives. पहले जो था उसका पूरा का पूरा change in the mentality of judicial as well as law. Daughter's right is foremost among such texts. Family property dispute of Tamil Nadu based property, ये 30 years back का केस है. Daughter to inherit the father's self-acquired property if there is no will. Case dates back to 30 years back. Family property dispute. A family of woman who died in 1967. Father died in 1949 without demanded a right of property, though father died intestate. Now this is the judgment. According to the judgment, if father died intestate, the woman, female, the daughter has a full right on all the Hindu property over collateral. What is collateral is explained in the whole judgment. Now I'm discussing whole Hindu Succession Act. I'm decoding whole Hindu Succession Act. पहले तो ये बोलता है हिंदू किसको बोलता है? Hindu include Buddhist, Jain and Sikhs. The act does not apply to Muslim, Christian, Parsi and Jews. The act applies to child legitimate or legitimate. There is no distinction between legitimate and illegitimate child. We are discussing something which will be unable to understand devolving of property in the coming slides. मैं सबसे tough concept है agnet. What is agnet? What is cognate? I will discuss in here first. That would be applicable later on. What is agnet? What is cognate? And what is the importance of agnet? What is the importance of cognate? Because पहले schedule 1 आएगा, schedule 2 आएगा, बाद में agnet आएगा, cognate आएगा. If all the four are not there, the property would be devolved to government. Agnet, when two persons are related to each other by blood or adoption, but not wholly through male, they are said to be agnet of each other. Section 3(1)(a) of the Hindu Succession Act. The agnetic relation may be defined, the agnetic relation may be male or female. For example, father's brother, grandfather are called agnet, including the ascending order. You, your brother's son and daughter are agnet in collateral line, agnet in ascending line, agnet in collateral line, agnet in descending line. Your son your son's son, your daughter are ignorant in descending. तो ये जो ignorant का कैसे चालू होता है? There must be a male in the start of each relationship. Hence, it will be ignorant. Ignorant in ascending line, ignorant in descending line, ignorant in collateral line. Ignorant means there should be a male, there should be a blood. It must be remembered ignorant relationship by blood and not marriage. Ignorant marriage not important. Let me give an example of ignorant. Ignorant में male चाहिए, blood relationship चाहिए, ascending में चाहिए, descending में चाहिए, and collateral में चाहिए. Ascending में कौन हो गया? Father's brother, grandfather, great grandfather, because these are all blood relationship. Brother, son, daughter, they are all ignorant in collateral. This is the judgment on the basis of this ignorant. Ignorant in collateral is the judgment which is pronounced by the Supreme Court by two judges, where they said ignorant in collateral would not have a priority over daughter. Cognate. When two persons are related to each other by blood or adoption, but not wholly through male, if the two are related through female, they are said to be cognate of each other. Under section 3(1)(c) of Hindu section है. यहाँ cognate में क्या है? When two persons relate to each other by blood or adoption, but not wholly through male. ये blood relationship है, but adoption है, but not through male. Male बीच में नहीं आता. Male is not necessary. For example, your father's sister are cognate. Similarly, your brothers. The Hindu section, the two persons say to be related to each other by half blood when they have descended from common ancestor but by different wife. Thus, the step brother. Section 3(1)(e) of Hindu section, the two persons are said to be related to each other by half blood when they are descended from a common ancestor but by different wife. Thus, the step brother, sister, or father's different wife are related to each other by half blood. अभी ignorant cognate हो गया. Now I am into full blood. Cognate complete हो गया. Let me I am somewhere. Let me discuss cognate again. When two persons are related to other by blood, but not or adoption, but not through male. For example, my father's sister's son. When two persons are related, or similarly your brother's daughter, son. Just remember a simple rule that whenever a relation between two persons are with another female or more than one female intervenes anywhere in the union of relationship, one is a cognate to another, but thus the daughter's son. There must be a male at the start of each line. Hence, it will be held ignorant and son's daughter and daughter's sons are cognate. Ignorant, cognate. Now half blood, full blood लेते हैं. If male died intestate, full blood. 3(1) of Hindu section, two persons are said to be related to each other when full blood when they are descended from a common father, common wife, full brother, full sister. If father or mother are different, it will be half blood. Section 3(1), two persons are said to be related either by half blood when they have descended from a common ancestor by different wife. If female is same, male is same, female is different, then it will be called half blood. Full blood, father and mother are same. Half blood, father same, wife different, mother different. Uterine. 3(1)(e) of Hindu, two persons are said to relate each other by uterine when descended by common ancestor have a different husband. Wife is same, but husband are different. Then it is called uterine. There's a woman having two husbands at the same time, or one after another, will give a birth to spades. Thus, when a woman having two husbands at the same time give a birth to other, it's called uterine blood. अभी हमने क्या क्या सीखा, कौन कौन मेल किसको ये अप्लाई होता है, किसको अप्लाई नहीं होता है, व्हाट आर द कास्ट, देन एग्नेट कॉग्नेट, then we have collected full blood, half blood and uterine. Now we are going into the definition. अगर मेल इंटेस्टेट डाइड होता है तो ये सेक्शन 8 लगता है, वुमन डाई होता है तो अंदर सेक्शन लगता है. अपॉन द हेड, फर्स्टली अपॉन अगर मेल मेंबर इंटेस्टेट डाई होता है तो सेक्शन 8, शेड्यूल 1, शेड्यूल 2, एग्नेट कॉग्नेट एग्नेट, and then it will come to a government property. So let us discuss firstly upon the heirs being relative, specified and class 1 of the schedule. Class 1 पहले देखा जाएगा. Class 1 में कोई भी प्रॉपर्टी है तो पहले उसमें फॉलो. Okay. Secondly, if there is no class 1, then being the relative in specified in class 1. Thirdly, if there is no harm in the first or second, then it would go to egnate of the deceased. Then it goes to a cognate of a deceased and then go to government. This is section 8. Order of succession among the heirs. Among the heirs specified in schedule, those in class 1 shall take simultaneously and to the exclusion of all other heirs. पहले class 1 में जाएंगे, उसमें हेयर उसको मिलेगा. If those who are not in the first entry of class 1, then it shall be preferred in the class of entry second. Those in the second entry shall be preferred to those in the third entry. जो class 2 में है तो class 2 में first entry वाले को पहला preference, second, third, इस तरह से preference जाएगा. class 1 में simultaneous, class 1 में जो भी होगा वो सबको simultaneously मिलेगा. Firstly, upon the heirs being relative of the specified class 1 of the schedule, the rule of the class 1, the intestate widow, if there are more than one widow, so class 1 में widow first आएगा, widow को 1 right. If there are 2 widow, 1 half, 1 half. There are 3 widow, 1/3, 1/3. The surviving son and daughter, जितने भी daughter है, suppose 10 daughter है तो सबको 1/10, 1/10 मिल जाएगा. Mother को 1, बराबर, there would be 1 to each. Okay. The surviving sons and daughters and the mother would be each 1. Suppose no, it would be like this. First में 1 widow है तो 1, 2 widow है तो 1 half, 1 half. 3 sons and 2 child, 2 daughters, so 1 each, mother only 1. The heirs of the each deceased son and each predeceased daughter shall be in the share of 1. Suppose एक सन है जिसको 3 daughter, 2 सन, 1 wife है, तो उसका एक शेयर है, उसमें से ये बाकी सब बांट लेंगे, वो ब्रांच गिनी जाएगी. ओके. अगर कोई ब्रांच में एक ही है तो उसको गिने जाएगा. Suppose let us start with say 1 widow, 3 sons, 1 mother and 2 daughters. तो 3 son, 2 5, 6 और एक widow 7. 1/7 each को जाएगा. 1/7 में फिर बाद में पार्ट होगा. Clear? Rule 1, rule 2, rule 3. I have explained in detail. Let me again count it. Widow, if 1 widow, 3 sons, 2 daughter, 1 mother, तो 1 would 3 plus 2 plus 1, 1/7 each को जाएगा. और each son, daughter would have its own branch. उसको अंदर बांटा जाएगा. Firstly, upon heir being relative class 1 should be the intestate of widow. The more detailed one will be the surviving son and daughter with the heirs of the branch of predeceased, जो मैंने ऊपर आपको समझा दिया. Rule full. Among the heirs of a branch of predeceased shall be so made that his widow and the surviving son and daughter get equal portion of a branch. अगर वो branch में son अगर नहीं expire हो गया तो उनकी जो हेयर है इनके ब्रांच को है वो इक्वल शेयर मिलेगा. Secondly, if there is no heir in class 1, then upon heir being the relative in class 2, अगर class 1 में कोई है ही नहीं तो class 2 में जाएगा. class 2 में एंट्री वाइज, फर्स्ट एंट्री वाले को पहले मिलेगा, सेकंड एंट्री वाले को सेकंड मिलेगा, थर्ड एंट्री वाले को थर्ड, फोर्थ, फिफ्थ, और एक एंट्री में 2 लोग हैं तो उनको आधा मिलेगा. So this is the way it will be taken care. And I have discussed schedule 1 and schedule 2 later on this game. थर्डली अगर वो फर्स्ट पार्ट में भी कोई नहीं है, फर्स्ट शेड्यूल में भी कोई नहीं है, सेकंड शेड्यूल में भी नहीं है, तो द ऑर्डर ऑफ सक्सेशन अमंग द कॉग्नेट एंड कॉग्नेट और एग्नेट अनकॉग्नेट. अब एग्नेट में कैसे जाएगा? Thirdly, if then there are no here of any of the two classes, then upon the agnate and dignate disease. Lastly, पहले agnate में जाएगा, agnate में नहीं है तो cognate में जाएगा. Lastly, if there is no agnate, then it will go to cognate. The order of succession among the cognate, as the case may be, shall be determined in accordance with the rule of reference laid down in. और agnate और cognate में भी तुम्हारा सबका एक डिग्री होता है. Of two has one of a fewer और नो डिग्री इज प्रेफर्ड. जो एक साथ में है तो वो पहले गिना जाएगा. फिर फादर, सपोज मैं हूं तो मेरा फादर, मेरा ग्रैंडफादर, मेरा ग्रेट ग्रैंडफादर, तो पहली डिग्री पहले मेरे लाइन में 0 आएगा, मेरे फादर में 1 आएगा, ग्रैंडफादर में 2 आएगा, ग्रेट ग्रैंडफादर में 3 आएगा. सेम विद सन, ग्रैंडसन एंड ग्रेट ग्रैंडसन, उसको डिग्री मेरा लेवल 0 आएगा. Where two numbers of degree ascent is the same or none, then preferred over a fewer or no degree. So 0 by pehla, then 1, then second. When neither of the entitled prefer to the other, rule 1 or take simultaneously. अगर दोनों में है तो simultaneously गिना जाएगा. Competition of degree मैंने आगे समझा दिया. एग्नेट उसमें डिग्री ऊपर और नीचे दोनों में कोई डिस्टिंग्विश नहीं गिने जाए. असेंडिंग और डिसेंडिंग में कोई फर्क नहीं आएगा. इधर उसमें सेम गिना जाएगा, सेम को वन ऑफ मिलेगा. इन द क्लास इन दिस शेड्यूल रेफरेंस टू अदर्स इन दिस शेड्यूल रेफरेंस टू ब्रदर और सिस्टर डू नॉट इंक्लूड रेफरेंस टू ए ब्रदर ऑफ ए यूट्राइन ब्लड. अभी हमने हाफ फुल ब्लड, हाफ ब्लड और यूट्राइन ब्लड बोला था. तो ये शेड्यूल में यूट्राइन ब्लड नहीं गिना जाएगा. व्हाट इज यूट्राइन ब्लड? फुल ब्लड मींस फादर मदर आर सेम. हाफ ब्लड मींस फादर सेम, वाइफ डिफरेंट. फादर सेम, मदर डिफरेंट. मदर सेम, हस्बैंड डिफरेंट. दैट इज कॉल्ड यूट्राइन ब्लड. यूट्राइन ब्लड है नो रेफरेंस इन क्लास 1. सन को एक गिना जाएगा, डॉटर को एक गिना जाएगा, विडो को एक गिना जाएगा, मदर को एक गिना जाएगा. सन ऑफ ए प्रेडिसेस सन, जो अगर सन का जो ब्रांच है वो उसका पहले गिना जाएगा, डॉटर की ब्रांच आएगी दूसरी. सन ऑफ ए प्रेडिसेस डॉटर, सन ऑफ ए प्रेडिसेस डॉटर, सन ऑफ ए प्रेडिसेस डॉटर को 1 गिना जाएगा. डॉटर ऑफ ए प्रेडिसेस 1 को 1 गिना जाएगा, बट वो ब्रांच में आ जाएगा. विडो ऑफ ए प्रेडिसेस सन, वो सन की ब्रांच में, सन उसका सन, इसका ग्रैंडसन. सन ऑफ ए प्रेडिसेस सन, डॉटर ऑफ ए प्रेडिसेस सन, विडो ऑफ ए प्रेडिसेस सन. तो ये ब्रांच के हिसाब से जाएगा. लॉ इज वेरी क्लियर एंड देयर इज नो एम्बिग्यूटी व्हेन यू कम टू अ कंक्लूजन. अगर आप गिनने जाओगे तो कोई प्रॉब्लम ही नहीं लगेगा. नाउ दिस इज शेड्यूल 2. फादर, अगर शेड्यूल 1 में कोई नहीं है तो फादर आए, फादर का पूरा 1 गिना जाएगा और फादर को पूरा का पूरा राइट मिलेगा. अगर ऊपर में कोई नहीं है, क्लास 1 में कोई नहीं है, क्लास 1 में नहीं है तो सीधा फादर का नंबर लगेगा. अगर फादर भी नहीं है तो सन्स, डॉटर सन, सन्स, डॉटर्स डॉटर, ब्रदर एंड सिस्टर, ये चारों है तो चारों को 1/4 मिलेगा. 5 है तो पांचों को 1/5 मिलेगा. नाउ दोनों में सेकंड में भी यहाँ एंट्री वाइज है. क्लास 1 उसका वो हेड गिना जाएगा, उसमें अंदर अंदर बांटा जाएगा. क्लास 2 में बांटने का कोई प्रोविजन नहीं है. फादर तो फादर को सब मिल जाएगा, सन सन्स का डॉटर को सन, सन डॉटर, ये अंदर अंदर बांट लेंगे. अगर क्लास 2 में भी कोई नहीं है तो डॉटर सन सन, डॉटर सन्स डॉटर, डॉटर्स डॉटर सन, डॉटर्स डॉटर डॉटर. तो ये जो है उसको एक गिना जाएगा. अगर सन भी नहीं है, डॉटर भी नहीं है, फादर नहीं है, सन नहीं है, डॉटर नहीं है, ओके, देन इट कम्स टू ब्रदर एंड सिस्टर. ओके, brother's son, sister's son, brother's daughter, sister's daughter. अगर वो भी नहीं है, ब्रदर सिस्टर भी नहीं है, देन फादर्स फादर, फादर के फादर को चांस मिलेगा, फादर के मदर को चांस मिलेगा. फादर्स विडो, ब्रदर्स विडो, फादर्स ब्रदर, फादर सिस्टर, मदर्स फादर, मदर्स मदर, मदर्स ब्रदर, मदर सिस्टर. ये 10th सीक्वेंस में शेड्यूल में जाएगा. अगर वो भी नहीं है तो हमने क्या बोला था, इट कुड गो टू गवर्नमेंट. Now this is for male, which we have discussed. Now we are discussing about the female. This is cover under section 14. Any property possessed by a male Hindu, whether acquired before or after the commencement of this act, shall be held by her full owner thereof, not as a limited owner. पहले limited owner गिना जाता था. Now, as per section 41, any property possessed by Hindu family, whether acquired before or after the commencement, shall be held by as a full owner thereof, not as a limited owner. Explanation. In this subsection, property includes both movable and immovable, acquired by a female Hindu by inheritance or device or a partition. ये उसकी खुद की प्रॉपर्टी है, कहीं से मिली है, मूवेबल है, एरियर है, सब स्त्रीधन में गिना जाएगा, except one case we will discuss later on. Okay. What is one? I'll let you know in a one go also. I'll put all this PPT in my blog, CA NITIN M PATHAK blogspot.com, as well as this presentation would be put on YouTube. And any question answer, any question which you have regarding this conflict, I'll guide you. You can just mail me nitinmpathak@gmail.com. We will give you all clarification regarding intestate or under Hindu Succession Act. Nothing contained in subsection 1 shall apply to a property acquired by way of gift or under a will or any instrument, under a decree or order of a civil court, under an award, where the terms of the gift will or gift or will or other instrument, or the decree or order award prescribe a restricted estate in such property. Nothing. अगर किसी कोर्ट ने ऑर्डर किया है तो इसका मतलब ये नहीं कि गवर्नमेंट 14(1) अप्लाई करो, 14(2) will be applied. General rules of succession in case of female Hindu. Up till now was a family. Now we are talking about female. Firstly, upon sons and daughters, including children of any predeceased son or father, daughter, and the husband. पहले किसको मिलेगा? Sons and daughters. अगर female death होता है, उनके son और daughter, including children of a predeceased son or a daughter, and the husband. Secondly, upon the heirs of the husband. Thirdly, अगर ऊपर वाले नहीं है तो heirs of the husband को मिलेगा. अगर heirs of the husband नहीं है, then upon father and mother. अगर father mother नहीं है तो upon the heirs of the father, then to mother. This is the way in which the distribution happens. अब फिर से बता देता हूँ. Son, daughter, husband. Then heirs of the husband. Thirdly, father mother. मतलब husband के साइड से अब फादर मदर की साइड आ जाते हैं वुमन की. एंड अपॉन द हेड ऑफ द फादर, हेड ऑफ द मदर. फिर से अगर फीमेल डेथ होता है तो फादर मदर सन एंड डॉटर का पहले राइट, हस्बैंड का पहले राइट. अगर हस्बैंड देन हस्बैंड नहीं है तो हस्बैंड के हेड का. अगर हस्बैंड के हेड नहीं है तो फादर मदर ऑफ ए फीमेल. अगर फादर भी नहीं है तो फादर के हेयर को. अगर मदर नहीं है तो मदर के हेयर को. These are the sequence in which it will be distributed. It is A is exclusive. A, P, C, D. पहले A, P, C, D इस तरह से गिना जाएगा. Any property inherited by female Hindu from her father or mother shall devolve in the absence of any son or daughter of the deceased, including them, not upon the father's heir, but one in the order of preference in the specified, but upon the heirs of the father. Any property inherited by female Hindu from her father or mother shall devolve in the absence of any son or daughter. अगर मुझे कोई प्रॉपर्टी मेरे फादर, कोई वुमन है उसको अपने फादर मदर से मिली है और उनके सन और डॉटर नहीं है तो इट विल डिवॉल्व अपॉन द हेड्स ऑफ द फादर. इसी तरह अगर किसी उसको हस्बैंड के साइड से प्रॉपर्टी मिली है और क्लास 1 के हेयर नहीं है तो वो हस्बैंड के हेयर को जाएगा. तो इन्होंने ये ध्यान रखा है कि फर्स्ट इट विल गो टू सन, डॉटर एंड हस्बैंड. अगर वो नहीं है तो उनका जो भी इक्वायर्ड राइट है वो उनकी डिवोल में जाएगा. The order of succession and the manner of this among the heirs and female, among the heirs specified in 1 those in one entry shall be preferred to those in the succeeding entry, and those in the same shall be simultaneously. Okay, excuse me. Yeah, which I already said. If any son or daughter of the intestate predeceased the intestate, then his child would get an equal right, which I already covered. ये मैं एक स्पेशल लॉ है, इसके बारे में मैं नहीं लिखता, बट इट इज लाइक द सेम थिंग, बट ये मैंने लोगों को जनरल बेनिफिट के लिए लिखा है, इसलिए इसमें मैं जनरल प्रोविजन. अभी ये जो जनरल प्रोविजन है, पहले मैंने क्या बोला था, हिंदू वो मेल के लिए, नाउ फीमेल के लिए. नाउ मेल और फीमेल के लिए जो लॉ है वो सेम है. यहाँ फुल ब्लड वुड बी प्रेफर ओवर हाफ ब्लड वुड बी प्रेफर ओवर यूट्राइन ब्लड. तो डेफिनेशन ऑफ मोड ऑफ सक्सेशन ऑफ 2 और मोर है. इफ 2 और मोर हैड सक्सीड टुगेदर, देन एज पर कैपिटल विल बी प्रेफर्ड. सपोज यहाँ एक एग्जांपल दिया है, वो मैं आपको बाद में कहूँ. यू कैन प्रोवाइड दैट द बेनिफिशियरी इनहेरिट through either per capital or per stripe distribution. The two types of beneficiary designation can have very different effect in terms of who inherits first. Stripes, per stripe is a Latin phrase that translates literally by roots or by branch. In the case of context, per strips distribute means that a beneficiary share passes to the linear discriminant if the beneficiary dies before the inheritance race. Per capita means coupled with Latin phrase means per head per capita. Tenants in common and joint common. Tenant in common and joint payment का distribution क्या है? I and my wife may be a common joint, but मैं और मेरा दोस्त है तो joint tenant बना जाएगा. तो A B यहाँ per capital, BCD is a per capita. यहाँ per strip B1 और B2, ये सी और डी को 1/3 मिलेगा और B1 बी को 1/2 मिलेगा. इसको पर स्ट्रिप बोलते हैं. और राइट ऑफ ए चाइल्ड इन वोम. इफ एनीवन डाइड एट द टाइम देयर इज ए चाइल्ड इन वोम, द चाइल्ड इन वोम हैव ए प्रेफरेंस ओवर चाइल्ड इन राइट ऑफ ए चाइल्ड. ओके, so when person dies at that time there is a child in a womb, the child in womb has got a full right as if he was live on the date of death. अगर कभी-कभी क्या होता है कि you died in an accident or you die and you don't have a death certificate date, or you die in a plane crash or in a number of reasons. In that case, you will not be able to decide the timing or the date of death. In that case, it would be presumed that elder dies first, then the later. Certain widow remarry may not inherit as widow. Presumption of the simultaneous. Certain widow remarry may not inherit. जैसे ही विडो का रीमैरेज हो जाता है, उनका ये जो पूरा जो राइट है वो बंद हो जाता है. Any heir who is related to one interest, widow of a predeceased or predeceased deceased, or widow or brother shall not be entitled to succeed to the property intestate of such widow as in the succession has remarried. Preferential right to acquire property in certain case. When after the commencement of this act, an interest in any immovable property of an intestate or any business. एक मिनट में आया है, 1 minute. Hello, yeah, I'm back to you. Preference right. Preference right to acquire property in certain cases, where after the commencement of this act, any interest in any immovable property in state or in any business carried on by him or her, were solely in conjunction with others. Where 2 or more heirs, especially class 1 or any of the two, to transfer his or her interest, the property business heirs shall have the preference right. कौन कितने बजे गया वो मेरे को लिख के बताना. चलो, preference right to acquire the interest on the सेक्शन 2 में ये बोलते हैं कि अगर प्रॉपर्टी डिवॉल्व होती है, अगर आप ट्रांसफर करना चाहते हो, पहले फर्स्ट यू शुड गिव अ राइट टू person among the heir. Right to acquire property, the consideration for which any interest in the property of a deceased may be transferred by section shall, in the absence of any agreement between the parties, to be determined by the court on application being made to in this behalf. And if any person proposes to acquire interest not willingly to acquire, so determined, such person shall be liable to pay all the costs. अगर ये लोग क्या बोलते हैं कि any property, business property or any immovable property, when you want to transfer it to someone outside, घर है, business है, so first you should give it to a person in the family, and उसका consideration court decide करेगी, court जो भी करेगी वो अपने पैसे पे निकाल देगा. If a person is liable to pay cost, तो जिसको चाहिए वो उसका पैसे का cost भरेगा, including how to derive the cost, वो court decide करेगी. Where Hindu dies, now this is preferential. जो प्रॉपर्टी इमोबल प्रॉपर्टी और बिजनेस है वो पहले फैमिली मेंबर को मिलेगा. अगर फैमिली मेंबर नॉट इंटरेस्टेड, देन ओनली it would be sold to outside, and then consideration will be decided by the court or mutually. Where Hindu estate has left surviving him or her, both male and female heads, specified in class 1 of the schedule, and her property includes dwelling house, wholly occupied by a member of his her family, then notwithstanding any containing this act, the right of any such female heir to claim the partition of dwelling house shall not arise until the male heir chooses to divide in the respective share, but the female heir shall be entitled to right of residence. What is that? Where such female heir is a daughter, she shall be entitled to right of residence in the dwelling house only if she is unmarried or has been deserted or has been separated from husband. तो ये लोग ये कहते हैं कि अगर एक हाउस इमूवेबल प्रॉपर्टी है, जो हाउस है जिसमें लोग रहते हैं, तो फीमेल would not have a right to ask to sell the property, and male would not be allowed to restrict the female member who was unmarried or who was married but entered daughter married but deserted or departed separated from the widow. So ये खाली एक अरेंजमेंट है कि मेल रहने का, फीमेल को उसको नहीं बेचने का राइट. So ये हो गया इधर. Murder disqualified. A person who commits a murder or abets the commission of a murder shall be disqualified from inheriting the property of the person murdered. एक ए आदमी है, इसने बी का मर्डर किया. Okay, now B has got a property C. अगर ये C property A को जाती है, तो he will not be entitled because he has murdered this person. Okay, एक मिनट में मर्डर वाला रेफरेंस. Okay, clear? A murdered B, or he has abetted somebody, asked somebody to murder B, and the property is C. Suppose property is D, and he has murdered B, and in that case also he will be entitled for D property, but not C, because C is the property of B. D is another property, so C he will be entitled for. So a person who commits a murder or abets the commission of murder shall be disqualified from inheriting the property of any other property in furtherance of succession. Converts descendant qualified. एक आदमी है जो हिंदू है, he converted himself to another religion. Now A converted himself into another religion. Now he has got B, C, D son. Out of that son, C and D chooses to be again Hindu. In that case, C and D, and on the death of intestate, on the date of death, अगर और वो डिवॉल्विंग द प्रॉपर्टी, अगर ये सी और डी अगर हिंदू होते तो इनको कन्वर्ट होने के बाद में भी चांस मिलता है, बट ए एंड सी को नहीं मिलता है. ए कन्वर्टेड हिमसेल्फ टू हिंदू टू अदर रिलीजन. ही हैज गॉट बी सी डी सन. सी एंड डी चूजेस टू बी हिंदू, एंड सी डी वुड बी एंटाइटल्ड टू a property. The convert will be disqualified from the property. Succession when heir, if any person disqualified from inheriting property, he will be dissolved. उसका कोई right नहीं. Disease, कोई भी आदमी को कोई भी disease है, does not mean that he is a defect. He will not be entitled to property. He would be always entitled to property. अगर हमने बोला था पहले schedule 1, schedule 2, cognate, ignate, अगर वो भी नहीं है, ignate, cognate तो भी नहीं है, तो property will devolve to government with all the right and liability to them. This is the law. Any Hindu may dispose by will or other disturbable property, and which is capable of being so disposed in accordance with the provision of Hindu Succession Act, Indian Succession 25, Indian Succession Act 1925, or any of that time being in force. For the removal of doubt, it is declared that content shall not affect the right of a maintenance. Suppose a person dies, he has according to his Indian Succession Act, he has devolved the property PCD to somebody else, but B is a daughter, then she will have a right to maintenance, though she has no right to the property. So maintenance ka right to rehta hi hai. Now we are going into judgment. Mrs. Sujana Sharma versus Manu Gupta, 2011. The court stated a clear and ambiguous interpretation to the object and goal of amendment section 2005 by extending that she will be entitled to a Hindu woman as a co-partner. The eldest co-partner will be the Karta. So now, after the 2005 amendment, woman can be the Karta if she is the eldest co-partner, and which will be validated by Mrs. Sujata Sharma versus Manu Gupta. Conclusion. इसके बाद 3 जजमेंट है, बट कंक्लूजन ये है कि पैट्रिशियल जो सोसाइटी थी has been converted into woman has got equal right. The recent judgment under section Hindu Succession Act, now general gender inequality, gender justice has come into force. Now co-partner. A co-partner is a person who acquires interest into Hindu general family by birth. The comparison between the co-partner and the member of HUB is that co-partner can, before the partition of HUB, a member cannot enforce it. It consists mainly, पहले क्या था, female were member but not a co-partner. But now co-partner and members different distinguished has gone after 2005. Okay, so now let us take a case that 2005 is the date on which the Hindu Succession Act comes. So if somebody is a daughter, live on 2005 date, 1st September, whatever date which will be there, so वो right उनके son का बनता है. If she dies before that date, her inheritance will not get a debt. If she is alive on that date, her right will continue. And the same is said that father is not there, male member is not there, but still the right would remain. In 2005, the father should not be alive, but the female, anybody who has a right should be alive. अब इनके लिए बहुत जजमेंट है, इसलिए गवर्नमेंट ने क्या किया, any partial partition, any partition which is not registered, which is not documented, which is not available before 2005. 2005 के पहले जो भी partition हुआ है, if it is not documented, it will not be considered as a partition, and woman's right will continue to be her own right. There are lakhs and crores of rupees are here in the this thing. Many women does not know these are their fundamental right. So many persons come and get their signature. चलो मामा, चलो फोई किसी को बोल के एक जगह पे घूमने ले जाते हैं, चाय पिलाते हैं, साइन करवा देते हैं, कोर्ट में ले जाते हैं. This is not true. Comparison between Hindu HUF and the Hindu joint family. It is a fundamental concept of Hindu law governed by the Hindu Succession Act. It is an ongoing process. जैसे मेल है वो बर्थ होता है, डेथ होता है तो अपने आप जाता है, कंपनी बंद होती है, बट हिंदू अनडिवाइडेड फैमिली, जॉइंट फैमिली कभी डेथ नहीं होता. इंडियन सक्सेशन एक्ट सेज even employing what to an end of by employing a partition. In Rukambai versus Lala Lakshmi Narayan, it is observed that the family continue to be joined in the family if it is divided in food, worship, and estate. Still, it would be considered as a joint family. In Chotelal versus Jandelal, it is held that joint Hindu family is neither a co-partner nor a judicial person, as it has to be no separate legal entity from its member. The Karta is the head of HUF, Hindu joint family, and all decisions are taken separately under the authority. Comparison between Hindu undivided family and Hindu joint family. Hindu order, it is an integral part of Hindu society, evolving on the basis of custom. The main requirement of joiner is a part of Hindu, is born in the family, co-partner. It is governed by Income Tax Act, which states that HUF as a person and its entity is a separate for the tax purpose, and Karta, co-partner, can file a return. Now members have been removed. In order to run its business, it may receive gain profit generated from business and would have different ending. It also holds a capital asset and capable of earning rental income. Individual can also use HUF as a tax planning measure, which is really still continue. Section 6 of the Hindu Succession Act states that the concept of statutory fiction of partition as a complex mechanism to ascertain the right of a man's surviving family member if he dies leaving behind him a female relative in class 1 of the schedule as a daughter. In such a case, the either earlier law stated that the said property holds shared calculated by imagining that partition took place 2005 के पहले कोई expire हो जाता है, तो it was assumed that it was no more, and इस तरह से partition गिना जाता है, but now 2005 के बाद में ये नहीं गिना जाएगा. In such a case, in the present case, the court held that the concept of statutory fiction of a partition did not entail an actual partition, and thus many statutory fiction of property taken place before the Amendment Act is not valid in the law. The new provision will have to be implemented on all the pending proceedings or appeal. This was the same case was decided in the case which we discussed. Further, the court noted that the matter is already due to conflicted decision and daughter cannot be deprived of the rightful equality and the access of property conferred by section 6. मैंने आपको बताया कि 2005 में जो डेट में जो डॉक्टर लाइव है वो सबको ये मिलेगा. 2005 के पहले मर गए तो नहीं मिलेगा. इनके डॉटर और उनके बच्चे को भी ये राइट मिलेगा. And all pending cases and appeal should be decided within 6 months. The historical amendment in section 2000 Hindu Succession Act provided the daughter as co-person with the same right in the co-person property as the son. The objective behind the amendment to change the patriarchal mindset, to remove the gender discriminatory through the Hindu Succession Act and provide the equal status to the son and daughter of a Hindu in the matter related to inheritance of a co-partner property. While this amendment brought changes in recognizing the daughter's right, however, there are several loopholes in the interpretation. Various issues have been raised in the judiciary in order to interpret latest development. In Prakash, in Fuldevi case, the Supreme Court held an amendment act was prospective in nature. Hence, from the passing of date of amendment, daughters would be a co-partner and have an equal share as of son in the case of joint in the property. The following should be noted. मैंने जो पहले बोला था ये फिर daughter must be live in 2005 in order to claim a share in the joint in the property. In case of a die before the enactment of this, her legal heir cannot claim the shares. 2005 में date को 1 September ऐसा कोई date है, तो if she is alive, she will be it. Daughter's father should be alive during the time of enactment in order to provide the status, but this has been reversed. The Amendment Act would not affect the alienation or the disposal or transfer of any joint property registered partition before the amendment. Government अगर ये partition पहले हो गया है तो उसको ये नहीं लगेगा 2005 के पहले. But court ने इसको किया कि oral partition will not be recognized or oral partition will be recognized only if there are some document available in the public forum. In Lokmani versus Mahadev Mani, Orissa. In case of a Lokmani versus Mahadev Mani 2016, the High Court stated that Section 6 of the Hindu Succession Act is given retrospective effect. And when the daughters were denied the right in co-partner property pending proceeding before the appeal, we now decided as per the amended provision and inequality can be removed. The High Court also stated that oral partition and unregistered partition deeds are removed from the definition of partition mentioned in Amendment Act 6006-5. What they are saying, any partition which is not written, which is not registered, unless it is in documented public, Otherwise, all old partition before 2005 will not be considered until it is documented. In Danma versus Amar 2018, two-judge bench held that two daughters would get a share in property even if their father had passed away before the amendment of 2005. However, there was a need to solve the conflict. The Supreme Court judgment, which was delivered right now, is on the basis of that. In Vinit Sharma versus Rakesh Sharma, 2018, further a court explained 665 of the Hindu Sect, we state that partition only by virtue of registered deed or parties are affected by decree of court, as the court can take of knowledge of oral document in exceptional cases only on the basis of long-standing evidence of a public clear document. Now, Hindu Succession Act partition done before 2005 will not be recognized. Also, court directed that significantly delayed due to conflicting decisions earlier by the High Court, subordinate court, to be disposed of involving the matter of within 6 months. So, Vinit Sharma versus Rakesh Sharma has given a lot of clarity on the judgment. Moreover, this case mentions point on the intent of section Hindu Succession Act, as it was neither the benefit of female successor prospectively nor able, but its main intent was to confer the benefit retrospectively. While stating the Amendment Act to be retrospective, it was held that it confers the female successor benefit on par with her male counterpart on their birth in Hindu property. ये लोग बोलते 2005 के पहले जो एक्सपायर हो गए वो फीमेल का राइट नहीं बनता, बट 2005 के बाद जो भी सर्वाइविंग है they would get equal right as if law prevail on their birth. So I think I've given a lot of clarity on the subject of Hindu Succession Act. I'll go through the whole section in 2 minutes time. Before that, we are conducting a regular seminar. Please join. We have got a blog, CA NITIN M PATHAK blogspot.com. यहाँ से आपको PPT, आज की PPT लिंक मिल जाएगी. I am in ISACA chapter founder president. I can guide you to any course of ISACA. I can guide you in CIA certified internal auditor, CSSP, many other courses which is related to information technology. This is our aim. Now I'm going back to the slides which start with. I'm going ये जो judgment है वो अभी deliver हो उसके बारे में judgment है. Now there is a definition of agnate, cognate. किसको हिंदू बोला जाएगा, किसको नहीं हिंदू बोला जाएगा. एग्नेट कॉग्नेट मैंने बोला है फुल ब्लड हाफ ब्लड, किस सीक्वेंस में हिंदू मेल की प्रॉपर्टी डिस्ट्रीब्यूट होगी, फॉल्स शेड्यूल, एंड देन द रूल्स ऑफ दैट. एग्नेट कॉग्नेट बाद में कौन सी डिग्री में कैसे डिग्री गिनी जाएगी, ये शेड्यूल है पूरा क्लास 1 क्लास 2. हाउ फीमेल्स प्रॉपर्टी इज डिस्ट्रीब्यूटेड, द सक्सेशन इन द फॉर्म विच इज गोज ऑर्डर ऑफ सक्सेशन. What is the definition of full blood, half blood, succession of 2 on male heir, stripes, per capita tenants, a right of a child, presumption of cult simultaneously, preference to acquire the property in case of this thing, special provision relating to staying murder. Murder में केस में क्या होगा, फीमेल की कौन सी प्रॉपर्टी, ड्वेलिंग हाउस में क्या होगा. आई हैव टेकन सक्सेशन, किसको डिस्ट्रीब्यूट, कब प्रॉपर्टी गवर्नमेंट ले जाएगी, टेस्टिमनी कौन किस तरह से टेस्टिमनी बना सकता है, रिसेंट जजमेंट वुमन करता बन सकती है, हिंदू सक्सेशन एक्ट कब से चालू होगा, रेट्रोस्पेक्टिवली, प्रोस्पेक्टिवली, एंड लास्टली हिस्टोरिकल जजमेंट ऑफ विनोद शर्मा वर्सेस राकेश शर्मा. With this, I end this presentation. Any question on this, you can mail me. I'll be pleased to answer through WhatsApp 9825804094 or nitin@pathak@gmail.com. Thank you once again. Thanks. I'm closing with this session. Thank you very much. Thank you.